In this session, we're going to continue our discussion of employment discrimination. This is part 2. So in our first video, we talked about direct evidence, and now let's talk about indirect evidence. So if you can't establish direct evidence, then you have to establish your claim using the indirect method. And through indirect evidence, you may also hear it referred to as circumstantial evidence. This is evidence that you can infer that discrimination was the reason for the action taken. So, like we talked about under the direct evidence, the statements or other proof establishes that the reason for the adverse action was a prohibited reason, a protected class, whether it was because of your race or because of your sex or your age or because of a disability. It was established that that was the reason for the action taken. Here, you don't have the strong proof that establishes it, but rather, considering the totality of the circumstances, the fact finder is able to infer that the reason the employer took the action, the adverse action, whether it's a termination or a demotion, whatever it may be, that action was taken because of a protected class, because of disability, your race, your age, something like that. So for the indirect method, the Supreme Court has established what's known as the McDonnell-Douglas burden shifting analysis. And the McDonnell-Douglas, that's the name of the case in which the Supreme Court established this burden shifting analysis. So initially, the employee has the burden to establish a prima facie case. If the employee is able to establish a prima facie case, then the employer has the burden to then articulate a legitimate non-discriminatory reason for its employment action. So it has to give a legitimate non-discriminatory reason for why it terminated the employee. If the employer can establish that legitimate non-discriminatory reason, then the burden goes back to the employee to rebut that reason by proving that it was pretextual, meaning that it was not the real reason for the decision. It was a reason designed to mask the discrimination. So let's just use an example so you can see what a prima facie case looks like. Here's what must be established to prove a prima facie case of age discrimination. This is under the ADEA, which we'll talk about in a few minutes. So to establish a prima facie case, the employee must establish 4 things: that he or she was within the protected class. So the protected class for an age discrimination claim would be that the employee was at least 40 years old at the time of the discrimination. The protected class, if it was a sex discrimination claim, would be that the employee is female. If it was for race, it would be that they are a minority. Then the second element is they have to show that he or she suffered an adverse employment action. We'll talk in a moment about what exactly constitute an adverse employment action. The third element requires that the plaintiff show that he or she was qualified for the position. This prong is there, but the courts have basically said that it doesn't take much to establish that you're qualified for the position. It's usually a claim or an element that is more or less ignored when you consider the prima facie case. Usually it's clear that the person is within a protected class, and it's usually clear that they're qualified for the position. So usually the prima facie case, if there's anything to argue over, it's whether there was actually an adverse employment action, or you argue over the fourth element, which is where you required to show that the plaintiff was replaced by someone outside the protected class. So here you'd have to show that you were replaced by a younger worker. If it was a sex discrimination claim, you would have to show that you were replaced by a male. You can also establish that fourth element, because if it's a sex discrimination claim and they hire a female, you're not going to be able to establish a prima facie case. But courts have said that you can alternatively prove that element by showing that there was a similarly situated, non-protected employee who was treated more favorably. So here, taking the age, if you weren't replaced by somebody outside your age category, then the employee may be able to prove that last element by showing that a similarly situated, non-protected employee, that would be someone who's comparable as far as uh, job duties, job function, skill, disciplinary history, somebody that's similar, and a non-protected employee, meaning that someone that is a younger worker that's comparable to them. If they can identify somebody that's comparable to them and younger that was treated better than them, and by treated better than them, we mean they weren't subjected to the adverse employment action that the plaintiff suffered, then they may be able to establish the last element here. And if you can establish these four things, then you're going to have a prima facie case, and the burden is going to shift to the employer to articulate the legitimate, non-discriminatory business reason for the adverse action, whether it's a termination or a demotion, whatever the action was, they've got to give a legitimate, non-discriminatory reason. So I said we talk about what is exactly an adverse employment action. That's defined as a materially adverse change in the terms and conditions of employment because of the employer's actions. So you're looking for a material change in the terms and conditions. So examples of adverse employment actions are terminations, demotions with a decrease in pay, material loss of benefits, or a significantly diminished material responsibilities. So if they take away your supervisor and they take away your supervisory responsibilities, that could be an adverse employment action. We talked about that last prong and how it can alternatively be shown by identifying a similarly situated person outside the protected class. So when we're talking about similarly situated, we're talking about comparators. And how do you know if someone is comparable to you? So the requirement is that you show that they're similarly situated to you in the relevant aspects. And so that's showing that you have similar job duties. You may report to the same supervisor. The expectations of your job are similar. But there are differences in job titles and responsibilities, differences in experience. If one has 20 years of experience and one has 4, they're not going to be comparators. If someone has additional education and someone doesn't, they're probably not going to be comparables. If one has much worse disciplinary history than another one, then they're probably not going to be comparators. And it's pretty much universally held that supervisors are never going to be someone that's similarly situated, because having management oversight is going to break any sort of similar comparable nature. So, like I said, once they meet the prima facie case, then the employer has the burden to identify a legitimate non-discriminatory reason for its actions. So essentially, they have to explain what they did or produce evidence of a legitimate non-discriminatory reason. The burden at this stage is considered light. If the employer articulates a reason, it's usually accepted, and you move to the next phase, which would be to decide if their reason is pretextual, meaning that it was not the true reason for termination. It was rather designed to hide or mask the true intention or the true motivation, which was a discriminatory reason. Some examples of legitimate non-discriminatory reasons that have been accepted by the courts: poor job performance. If you can establish that the person was doing a poor job, if they had been put on a performance improvement plan and had not improved, that is going to be favorable to show that they were terminated for a legitimate non-discriminatory reason. Poor job performance has nothing to do with someone's race, their age, their sex, etc. Violation of your rules and policies. If you've got a policy that's a safety rule and someone violates a safety rule, and violation of the safety rule usually results in termination, that's a legitimate non-discriminatory reason that's not connected to a prohibited class. Absenteeism, dishonesty, inability to work with coworkers, financial hardship, all of these are reasons that are legitimate and non-discriminatory. So if the employer is offered one of these reasons, then the burden shifts back to the employee, and the employee may establish that this reason given is pretextual, and they could do that by showing one of three things. They can show that the reason has no basis in fact. So if you say there's poor job performance as your reason, and they can show, well, my sales numbers are as good as someone else, of my coworkers, I made as much money as them, whatever it may be, then there's no basis in fact. And if they show that the reason did not actually motivate the challenge conduct, if they can say, well, we terminated you because of you violated the safety rule, but they can point to other people who were outside the protected class. So if it's our age claim, if they can show that there were younger workers who violated the same rule, but they were never terminated, that may be a basis to show that what the violation was not sufficient to motivate motivate discipline. And so if that wasn't enough to motivate it, then it had to be some other reason that motivated it. Lastly, they can show that the reason is insufficient. And so if they can show that, again, going back to the thing, it may be insufficient reason for termination because they didn't terminate other people that have had the same safety violations. Now, in response, this is a very valuable tool for employers. Is you can it's basically a defense to the pretext argument. Is even if they say, hey, there's pretext here, the employer can say, well, we had an honest belief in why we terminated him or her, and so the doctrine is basically that so long as the employer honestly believed in the legitimate non-discriminatory reason that they gave for the employment action, then the employee cannot establish pretext even if they show that the reason is ultimately found to be mistaken, foolish, trivial, or baseless. So even if they mess something up and they can establish that, well, it shouldn't have been sufficient to terminate him, if they can show that let's take the safety violation, if they can establish that they honestly believe that he committed the safety violation and that was sufficient to warrant termination, then it doesn't matter if the employee can come back and show that he did not, in fact, violate the policy. If he didn't violate the policy, then he shouldn't be terminated. So basically, he would be showing that the employer's reason, i.e., the safety violation, he's actually showing that that's wrong. That was a mistake, that he didn't actually violate it. Well, under the honest belief doctrine, as long as the employer was able to reasonably rely on particular facts before at the time the decision was made, then they're going to be entitled to the honest belief doctrine. And that means that there's not going to be the employee's not going to be able to establish pretext. So if in the context of what we've done with the employee, if he comes in and he shows that I did not in fact violate the safety rule, well, if the employer is able to point to particularized facts showing that it undertook an investigation and that the investigation revealed that 3 people testified or gave statements that the employee violated the policy, then the employer has a reasonable basis to believe that the employee violated the safety policy and should be terminated. If the employer's relying upon those particularized facts before it at the time it made the employment decision, it doesn't mean that it was pretextual simply because at a later date the employee can come back and establish that the employer was wrong. So the honest belief doctrine really helps shield the employer from subsequent information that can be learned that would discredit their reason for termination. So if you're going to show that there was a mistake in the process or they didn't look at the right records or whatever it may be, the employer's decision-making process doesn't have to be optimal or leave no stone unturned. Rather, they just have to be showing that the employer made a reasonably informed and considered decision before taking the adverse employment action. The scenario I just gave, if they interviewed 3 employees and those employees supported that um, the plaintiff violated the safety policy, then they've got a reasonable basis before them. They made a reasonably informed decision by talking to various people. They gathered information on it. They may have not had an optimal investigation and have left no stone unturned, but they did enough and had particularized facts before it to support their belief that the employee committed a safety violation and therefore should be terminated. Retaliation. Switching gears from discrimination, we talked about how we establish a discrimination claim. We'll talk a little bit more about each of the statutes and what they require and prohibit. But that's the framework that establishes a discrimination claim. You've got the direct method or the indirect method. And when we talked about retaliation, it's very rare to have direct evidence. It's possible that you could have direct evidence of someone saying, I'm terminating them because they filed an EEOC charge or because they opposed some unlawful activity that we were doing. But most of the time, probably 95% of the time or more, retaliation claims are proven by indirect evidence. So when does retaliation occur? Retaliation is when an employer takes an adverse action against an employee because that employee engaged in protected activity. So to establish a prima facie case, the employee has to show these 4 things. They have to show that he or she engaged in protected activity. And don't worry, we're about to define protected activity. Second, the employee must show that the employer knew that the employee engaged in protected activity. Third, the employee must have subsequently suffered an adverse employment action. And lastly, there has to be the causal connection between the adverse employment action and the protected activity. So what is protected activity? You've heard the term used a couple of times by me now on the prior few slides. Protected activity, there's 2 types. You have opposition activity is the first type, and you have participation activity. We'll talk about participation on the next slide, but opposition activity is where the employee is opposing unlawful discrimination. So your opposition has to be based on a reasonable good faith belief. You have to have a reasonable and good faith belief that the employer is engaged in a discriminatory conduct. It's got to be that they're discriminating against someone based on one of the protected classes of age or sex or race, disability, any protected class. And you've got to have a good faith belief that they're engaging in that unlawful discrimination. And then you've got to clearly object to that discriminatory conduct. If you don't object sufficient that the employer knows that you're objecting based on protected classes, then you're not going to engage in opposition activity. Vague charges of harassment or discrimination are not enough. You've got to give specific information and make it clear to the employer that you're objecting or opposing their unlawful discrimination. So protected activity on opposition oftentimes boils down to exactly if what the employee said is sufficient enough to establish opposition. Participation activity, these are usually most of the time based on participation in either filing an EEOC charge or participating in someone else's EEOC charge, like giving testimony in an EEOC investigation. That would count as participation, or you're participating in an internal investigation about a claim of sexual harassment or a hostile work environment, something that you're participating in. So the second requirement was that the employer must know of that protected activity. So the employee has to engage in either opposition or participation activity. Then the employer has to have knowledge of that protected activity. Knowledge is essential. if the decision maker that has to know that the employee is engaging in protected activity. If the decision maker does not know that the employee engaged in protected activity, then there can be no causal connection. Um, the the protected activity can't be the motivation for the adverse employment action. It can't be the motivation for the retaliation, because without knowledge, you can't be retaliating against somebody. So it's important to establish that the employee, specifically the decision maker who is charged with retaliating against you, that person, the decision maker, knew of your protected activity, because without the decision maker knowing that, then the decision maker can't be motivated to retaliate for your protected activity. The adverse employment action, we talked about that a few moments ago under the discrimination, and it's actually a little different here. There it was a materially change in the terms and conditions of employment. Here it's a lighter standard. What you have to show is that the action was sufficient to dissuade a reasonable worker from engaging in protected activity, such as dissuading them to make or support a claim of discrimination or a complaint of discrimination. And the last requirement is that the employee establish a causal connection between the protected activity and the adverse employment action. Many times, to establish this, employees will rely upon temporal proximity. That means that they rely upon the close connection between their protected activity and their termination. And they want the fact finder to infer that the employer took the adverse employment action because of the protected activity. They don't necessarily have any proof that the adverse action was taken because of them engaging in protected activity, but they believe because it was close in time that it is sufficient to infer that it was the motivation. Well, the courts have kind of pushed back a little bit on this concept, and basically for temporal proximity to be sufficient, the action must be very near in time. There's no exact rule on how near in time that has to be, but it is settled law that anything greater than 6 months is insufficient and requires additional proof of acts of discrimination. So you've got to show the temporal proximity plus other acts of discrimination to support the causal connection. Now, if it's less than 6 months, it just depends on the facts of the case. There are some cases that will say that 2 months is enough time between the protected activity and the adverse action, but there are cases that go the opposite way and say 2.5 months is not enough time. Anything just a few weeks or a month is going to be probably enough to allow you to infer the causal connection between the protected activity and the adverse employment action. And once you get to 2 months and past, it's really going to depend on the court and just the facts of the case.